Hello, everyone, and welcome back. My name is Greg Eck of the Law Office of Gregory J. Eck, and today I'm continuing our conversation about the H-1B visa. What I want to talk about today are requests for evidence within the H-1B context, and I'm going to provide the 5 most common reasons why USCIS issues requests for evidence. The first one has to do with specialty occupations. What this means is that for an H-1B to be approved, the job itself must be considered a specialty occupation. What is that? A specialty occupation is a job that requires at least a bachelor's degree or its equivalent in a specific field of study. Right? So a general or generic bachelor's degree is not going to be sufficient. The job must require a specific degree in a specific field. The job also requires that the applicant himself must possess that specialty degree. So, for instance, if you have a job that requires a degree in biology, then the foreign national must also possess a degree in biology. Sounds simple, but USCIS often finds that the job descriptions that are presented to them for a specific job are too general. And therefore, they'll push back and say, we need you to prove that this is a specialty occupation. An example would be if you had a job that required a business degree, but the job itself was very generic, involving job duties that could cover a whole host of degrees within a very, very broad field of business. That might not be sufficient for USCIS, and they may require that the U.S. employer provide additional evidence to prove that this position is, in fact, a specialty occupation. So, what to do if you get one of these requests for evidence? Well, what you need to do is be very, very precise from the beginning. All right, make sure that the job itself requires a degree in a specific field of study, and then, of course, make sure that your proposed foreign worker possess that degree. All right, very important. Prepare in advance. All right, what is the second most common RFE? This is one called the employer-employee relationship. All right. Oftentimes, you might see this in the context of a contract worker or a 1099 worker, where the USCIS is not convinced that there is a true employer-employee relationship between the petitioning employer and the beneficiary foreign worker. So in order to overcome this particular challenge, you just want to make sure that there is, in fact, an agreement or contract for employment, usually in the form of some kind of an assigned employment agreement. All right. Also, it's very helpful to have an organizational chart showing the chain of command from the executives of the company down through to including the foreign worker that you wish to employ, showing that he or she fits within the organizational structure of the company. Another way to do this is to provide performance reviews that have been conducted by that individual's supervisors, also showing that he or she has been, in fact, employed by this particular company, by the petitioning company, in an employer-employee relationship. So that's the second most common reason for the request for evidence. What is the third one? The third one has to do with the beneficiary's qualifications. Sometimes the USCIS is not convinced that a foreign worker actually possesses the qualifications required for the job. All right. Sometimes this happens if the individual has a degree from a foreign university and there is not evidence that that degree is the equivalent of a U.S. degree. All right. What can you do when this happens? You can have the degree evaluated. Right? I always do this well in advance of submitting the H-1B, so I know well in advance that this individual actually has the equivalent of a U.S. degree in a specific field. Remember, specific field is very important, all right? So when you're preparing your H-1B application, make sure that you gather the individual's diplomas and all of their grade transcripts so that you can know well in advance that this individual does in fact possess the equivalent of a U.S. degree. And then submit those for an evaluation by a credential evaluating company. There are many online, and you can check online to find out what the best ones are. I have a small handful, and you can check or ask me in the comments below what my recommendations are. I'm not paid to do any of this, but anyway, you can look up on Google what are some good credential evaluators that are competent to do this for immigration purposes. All right. What is the fourth one? The fourth has to be, the fourth one is related to what's called the availability of work, all right? Because sometimes USCIS is not convinced that the employer has sufficient work to support a full-time or to support an H-1B worker for the duration of the period of H-1B employment, all right? So sometimes they're going to ask for additional evidence that this proposed H-1B worker isn't going to be simply employed, say, on a 6-month basis as kind of a contracting or consulting sort of role. USCIS is going to want to see that this individual, or I should say the employer, has sufficient work to sustain the employment of this individual over the period of term that you're requesting H-1B status. All right. The best way to deal with this, once again, is through preparation. Make sure in advance, if you are the attorney preparing the H-1B application, find out from the employer the exact nature of the job. Make sure that it's extended over the period of the term and that there is sufficient work. Oftentimes, this is a problem with a very small employer that might be a small 1 or 2 person shop, and there might not be sufficient work for the H-1B worker to do. So just be on the lookout for that well in advance so that you can prepare. And the fifth most common one has to do with wages and the labor condition application. All right. Oftentimes USCIS is going to be concerned that the offered wage is too low for the proposed position. Right? Where does this come from? Well, there have been in the past years a lot of examples of very, very large companies that are hiring foreign workers and offering the lowest possible wage within the wage structure on the labor condition application, as a way of course, keeping their eye on the bottom line and paying people the least amount possible. USCIS, however, is very concerned about protecting American workers, and they want to make sure that individual workers that are being hired for a particular job aren't being offered wages that are too low for either the experience that they have or the experience that the job would require. So what's the best way that you can address this? Once again, prepare. Ask your employer in advance what are the exact requirements for this job and how many years of experience, for instance, would this job require. And if it is not an entry-level job, you can't put on the labor condition application that it is, in fact, an entry-level job as a way of keeping the proffered wage lower than it should be. Just be very careful about that. Talk with your employer. Make sure that the proffered wage is actually fitting with the individual that you wish to hire and with the years of experience required for the role. Now, those are the top 5 most common reasons for USCIS to issue requests for evidence. Of course, there are other reasons. Oftentimes, they just want additional information, say, related to the individual's foreign address, or maybe a particular date or item of information on a form was missing, something sort of administrative like that. But those were the 5 most common reasons for a request for evidence. And as always, like I've been saying throughout this, be prepared. Plan in advance. And like walking through a jungle, you don't want to go through it by yourself. Always have a good guide. I recommend legal counsel. It could be myself, it could be any other trusted attorney. But you don't want to do this by yourself, because within the H-1B context, there's a lot of thorny statutory issues that, if you're not aware of, could come up and bite you later on. So best to be prepared in advance and have a guide. So it was really great talking to you about this H-1B RFE question. And as always, remember to like and subscribe. Leave your comments below. I am Greg Eck of the Law Office of Gregory J, and I will see you on the next one. Have a great day.